Dan, would you like to start for us today?
That would be my pleasure. So good morning all and happy Workforce Wednesday. Welcome to our WEDTalk webinar featuring employment attorney Marc Scheiner to discuss ADA accommodations in the workplace. I'm Dan Fogarty, the director of the Berks County Workforce Development Board. It's my pleasure to host WEDTalks again with my Bucks County colleagues on behalf of your neighbors up here in Berks County. So I'm thinking that there are some Berks County folks on the call right now, and I'm pretty sure there might be some Taylor Swift fans as well. Any Taylor Swift fans out there? So some could say that Taylor Swift and her family are, got a bunch of them. So Taylor Swift and her family are suburban legends up here in Berks County. Before conquering stadiums worldwide, the multi-platinum Grammy award-winning artist began her musical journey singing at local events in Wyomissing and Reading. And as everyone knows, it's been a whirlwind of success ever since then. Last year, Taylor's Eras Tour grossed more than $1 billion. That's billion with a B. And Time magazine named her Person of the Year. But Taylor retains her strong Pennsylvania roots and a community that has supported her from the very beginning. So the next time you hear Taylor's music, remember that the global sensation found her starlight right here in neighboring Berks County. So with that, I'd like to turn things over to my colleague, Billy Barnes, Executive Director of the Bucks County Workforce and Economic Development. Billy?
Good morning, everyone, and thanks for the introduction, Dan Fogarty. The Americans with Disabilities Act requires employers to provide reasonable accommodations to qualified employees with disabilities. These accommodations enable an individual with a disability to have an equal opportunity not only to get a job, but to successfully perform their job tasks to the same extent as people without disabilities. How can employers better handle requests for accommodation, assess whether the accommodation can be granted, and mitigate litigation risk? Let's find out. It's my pleasure to welcome Marc Scheiner back to WEDTalks. Marc practices at Duane Morris in Philadelphia, where he advises clients on a variety of employment issues. He represents clients in employment litigation matters and trains human resource professionals, in-house counsel, and supervisors on a range of workplace topics. Please help me welcome Marc Scheiner. Marc?
Billy, thank you so much. I appreciate the kind words, the welcome, and Dan, thank you for the facts I did not know. So I will appreciate that more next time I listen to some music. Welcome, everybody. Great to be back. I feel like it's been a long time, and yet it's been no time at all. I was last year in November. Here we are already at the end of April. I cannot believe it. And we're here to talk about ADA accommodations. I know from interacting with folks in Bucks County, as well as just hearing from some folks over the time last year, we have a lot of small businesses here. We have a lot of small businesses that are well under 50 employees. In other words, you are a company, you're an organization for which the FMLA is not applicable. And so oftentimes, many of us think about leave issues with the FMLA in mind, and some small businesses either are not aware of their obligations under the ADA or are confused by them. Many larger organizations where the FMLA is applicable still forget about the ADA. So my intention here is to shed some light on this hot topic. If you're not aware, failure to accommodate claims and disability claims on the basis, discrimination cases on the basis of disability are really hot topics, really trending higher and higher. If you have avoided this, good for you. I hope that your luck keeps lasting. But inevitably, my view is organizations of all sizes are going to interact with the ADA. And I want you to interact with it from a proactive approach, thinking about these issues, knowing your obligations, being comfortable in how to handle this, work through it, with it, and not be dealing with this when you get a charge of discrimination from the EEOC or from the PHRC. So I'm ready to dive right in. And what I'm going to do is I'll show you some of my themes. These will be some themes that I sort of weave throughout. You may know, if you've seen my presentations before, we were last together, like I said, in November, talking about employee handbooks. I'm not a PowerPoint slide reader. These slides are helpful, perhaps. We'll use them. I'll use them. There's some takeaways, but I'm not just going to sit here and read PowerPoint slides to you. I want to engage and talk through some of these issues, highlight some of these themes, and think about this from a really practical perspective. We only have a short bit of time, but still I packed in 10 hypos into the presentation. And I'm hoping, especially when we get to the hypos, that we can have some interaction through the chat, perhaps. You could also unmute yourself. I'll leave a few minutes at the end for questions, but primarily I want to hear your questions throughout. If you have any question about anything I'm going through, feel free to plunk it into the chat, and I'll do my best to weave that in. I'll also leave my contact information at the end, so if you have any lingering questions or follow-ups, feel free to reach out to me. Andrea mentioned that some people have their chat disabled by their organization or your particular version of Teams. If that's the case, you could unmute or do your best to reach out to me afterwards if you don't have the chat function. One thing I want to make clear throughout this is the expansive coverage of the ADA. Even when, I don't want to talk about the FMLA too much, but just by virtue of comparison, by way of comparison, the FMLA is actually pretty targeted and pretty limited. The ADA is much broader, and oftentimes organizations are not aware of this or forget this. I want to touch on this. Of course, I want to touch on what are our obligations as companies, as employers, organizations of all kinds in this area. Primarily, we'll talk about reasonable accommodations in the interactive process. I will leave some of the other things for our ongoing conversation today, but I will just point out the need to train managers and supervisors. Your managers, your supervisors are often the so-called front lines. They're the ones that are hearing the requests for accommodations. Do they know, do we know, but do our managers know what a request for an accommodation looks like, sounds like? Do they know how to respond or how not to respond? Do we know how to respond or not respond? These are really essential things because your whole organization is going to likely be on notice of a request through your manager. And if your manager is not even aware that a request was made, we are in a tough spot. And then we are certainly maybe dealing with this from a litigation perspective or the charge perspective, not that proactive HR policy and day-to-day navigating perspective. So let's get on the right side of that is my goal for all of us. So again, let's just jump right into it. I'm going to cover some background basics a little bit more quickly. I'm not assuming knowledge here, but I'm assuming some of us have some basics here. If not, it's okay. I'm going to go through this on the quicker side. Feel free to ask questions. I really want to save more time to engage with this a little bit more through our hypos. So background, if we are an employer with 15 or more employees, so 15 is the threshold, we are covered under the ADA. But even if we are smaller, we are likely covered under various state laws. Here in Pennsylvania, 4 is the number. The PHRA, the Pennsylvania Human Relations Act, requires a threshold of 4. So unless you're an organization of fewer than 4 folks, you're going to have some kind of coverage here. And for our purposes, the PHRA and the ADA are analyzed and looked at very similarly. So all my comments effectively regarding the ADA are applicable to the PHRA. So I think most of us here are having at least 4 employees. We're going to have to think about these issues. Unlike the FMLA, there's no service requirement. I sometimes say that coverage under the ADA begins not just on day 1, but on day -1. Applicants are also covered by the ADA. Our focus today will be on employees. It's more common, but just know, maybe we'll do a presentation on hiring stuff, or deeper or other issues. But in the interview and hiring process, if somebody needs an accommodation to deal with the interviewing hiring process, we need to consider that as well. And again, no tenure requirement, no 1 year of employment. From day 1, somebody is covered under the ADA. All right, that's their basics. 2 key areas. One is non-discrimination, and then one is the reasonable accommodation piece, which is our main focus. But before we get there, let's just remind ourselves that the ADA is also a non-discrimination law. So we as employers cannot take an adverse action on account of someone's disability. We'll define disability in a moment, but when we're thinking about disability here, we're thinking about a current disability, a prior disability, perceiving someone as having a disability, and someone who's associated with someone else, like a caregiver who has a disability. So I currently have a disability. I'm currently undergoing treatment for a kidney condition, dialysis, let's say. I am covered under the ADA, current disability. Let's say I recovered from that situation a year or two ago. I'm still protected under the ADA as somebody who had a prior disability. I no longer consider myself to be disabled or to have a disability, to have a kidney condition. I'm still covered. Perceived as or regarded as disability, maybe you suspect somebody has a disability. Maybe, you know, I've actually seen this before. It sounds like I'm making this up, but I've seen situations where, and read some cases about, thankfully none of my clients were involved with something like this. An employee came in with significant hair loss. And if that employee is treated by an employer, supervisors, managers, as let's say having cancer, I'm not sure how that would actually roll out. There's all sorts of scenarios we come up with, but perceiving somebody, regarding somebody as treating somebody differently because you think they have a disability, even if they don't, still now all of a sudden they're protected under the ADA. Sort of a strange situation, but it happens every so often. And a caregiver, you take care of somebody who has a disability, you're also protected under the ADA. So a broad protection on this discrimination provision. So let's look at disability. Let's pause there. A disability is a physical or psychological impairment that substantially limits a major life activity. Many of us have probably heard this definition before. Now, the ADA was passed in 1990. It was significantly updated in 2008. And in 2008, the definition of disability was not so much revamped, but how it was analyzed was revamped. I'm not going to go through all the changes that were made. As Dan and I were saying before we started, 2008 seems in some ways not that long ago, but it was a while ago. So I'm not going to go through all the differences because we have the law as it's been for a long time now. But when I say that this definition is construed in favor of broad coverage, that's the way the EEOC looks at the issue, and many states and federal courts would look at this issue. In other words, we should not be, the case law, the statutes now telling us we should not be taking a lot of time to analyze really whether somebody has a major life activity that is impacted, what's the degree of impact. There's broad coverage. And so major life activity used to be things more like standing, stooping, bending, lifting, very physical oriented requirements. Maybe it could have been in some situations, can I take care of myself? Can I do proper hygiene functions? That sort of thing. Now major life activity has been really expanded to, one example is major bodily functions. So I gave an example in passing a few moments ago about a kidney condition. A kidney, you know, the functioning of your kidney is the functioning of an organ, which is going to be covered now as a major life activity. I have an issue that impacts my circulatory system. The circulation of blood through my body is a major life activity. Breathing, a major life activity. These are things that we used to not think of as major life activities, even though they clearly are, in the sense that we need to have blood move through our bodies and oxygen move through our bodies to live. These sort of situations now lead to the conclusion that many more people are likely to fall under the umbrella of a disability. Episodic conditions, conditions in remission, all of these are potentially disabilities. Now, just because we have people with disabilities, the definition is expanded and the number of people who are under that umbrella and that definition is expanded, that doesn't mean that we necessarily have to do anything about it. This is then turning us to the reasonable accommodation analysis. But effectively, the analysis begins with the question, maybe somebody has a disability. Does it impact their job? If not, then we're really probably not even talking about it. Does it impact their job duty in a way that doesn't allow them to do parts of their job? And we have to sort of take that analysis further, and we'll think more about it. But just because somebody has a disability doesn't mean they need anything as far as an accommodation, and it might not mean that we have to provide anything, but there's an analysis to be done. So, and again, I'm going through this, use the chat, just as a reminder. So our accommodation obligation as employers can be summarized here, and we're going to break this down for sure. We have an obligation to make reasonable accommodations for employees or applicants with a disability, provided that the accommodation does not impose an undue hardship on us as the employer. And one key point I will make here, and it was on my initial theme slide, it'll come up a few times, this is an individualized case-by-case determination. And I sometimes quip that, some of us in HR or lawyers, or HR lawyers, we like bright line rules. In HR world, there's probably not all that many bright line rules compared to other areas of the law, but when we can take a bright line rule, we love a bright line rule. Here is a great, in the sense of clear, bright line rule, case-by-case individualized assessment. But that is, of course, the worst bright line rule possible, because while it's very clear that we have to make an individualized case-by-case assessment, what that means is in no way clear, because it means every situation has to be looked at differently. We could have, as we'll say, or I'll say at some point, probably I'll say it now, we could have two employees with the same medical condition or disability. Maybe one person is impacted in their job, maybe somebody is not impacted by that disability in their job. So maybe they have different needs for an accommodation. Maybe they have similar or different accommodation needs. Maybe we could grant one employee their requested accommodation because of the nature of their job, but we can't accommodate the other employee with the same condition because of the nature of their job. We could have different results. Those are optical issues. Those are employee relations issues. You might want to find ways of having similar outcomes, but the reality is each situation is different. Each employee is different. Each job role is different. Each set of job duties is different. The obligations and burdens of our coworkers, of the organization may be different depending on what's needed. So we could have different results. We'll see about that as we talk more. So looking further at our reasonable accommodation obligation, we're required to provide one to somebody with a disability, but we're not required to eliminate essential job functions. So one maybe silly example, but it's a real one too, is forklift driver. I work in a warehouse and my job title is forklift driver, forklift operator, and what I do is I operate the forklift in various ways throughout the day. That's what I do. If I have a disability, medical condition, that for some period of time does not allow me to operate a forklift, that is the essential function of my job. Now, some organizations, some warehouses will have light duty positions available in a temporary basis to encourage people to come back to work or work in limited capacities for some period of time. Okay, you could do some sweeping. You could help us do some office filing. And if that's in line with your restrictions for your disability, that might work for some period of time. But if you don't have those jobs available, and as a side note, employers are not required to create positions as far as an accommodation. You don't have to create a new job to accommodate somebody to work in that new job that either doesn't need to be done at all or doesn't exist. But maybe you find something for them, great. Or maybe for a limited period of time, fine. But if you have a different scenario where somebody's working in the same warehouse, but their job is warehouse operator, and as part of their job, they drive the forklift, they deal with organization of boxes and packages, they do some packaging up and shipping of product. All right, now we have a variety of maybe 3 or 4 tasks, and maybe this person can't drive the forklift for the next 6 weeks due to recovery from a surgery relating to a disability. Well, now we could maybe more easily imagine a situation where this same person, different title, different job functions, could not do the forklift, have some coworkers do more of the forklift responsibilities, and this individual employee is maybe doing more of the boxing up, maybe more of the shipping and packaging piece of it for that period of time. That would be a way of looking at what needs to get done, what this person does, and figuring out a way of accommodating it. Job descriptions, I don't want to go too far down this, but I'm flagging it for you. Job descriptions are a great place, an ideal place to list what essential functions exist for particular roles. If you need somebody to be on site and not remote, for instance, good place to mention that is in a job description. Essential function is driving the forklift. Important. Concentration. You know, we might think that concentration and attention is important for every job. That's not really true, or it's true to different degrees. If I'm going to be flying actually later today, the people who are at the airport in the flight control tower, that requires a high degree of concentration and attention. I assume the pilots, even with a lot of computer assistants, need a lot of attention and concentration. I certainly hope so. How about the rest of us? I don't know about you, but like, you know, I am here, but, you know, I'm doing a whole bunch of other things. You know, you see my hands, but I'm doing like tabs and phone, you know, I'm not. But, you know, we're not fully aware or as attentive. We might be in a conversation, but we don't need to have our attention for a full 4 or 8 hours. Although I hope you're fully attentive to me right now. Just like I'm not on my phone, you're not on yours, or different tabs, right? No, but the reality is attention and focus and concentration means different things. So if we're going to put something in as essential job functions in our job description, let's make sure they're really essential functions. And then we can look at that as a basis. It's not going to answer all of our questions. The answer is going to be, or the focus is going to be, what does the person actually do, not what their job description says. But it's a good starting point. Now, when we think about undue hardship, whoa, I can't imagine pulling that person off of the forklift, having them do more of other things and asking some other folks to work the forklift more, because that's just not fair. Well, that's not really part of the analysis. And having coworkers step up in those ways, work additional hours sometimes, including overtime, that's going to be really not sufficient to show undue hardship. If you have to violate a collective bargaining agreement in order to get staffing, violating a CBA is not required. If you have to hire somebody to effectively shadow your employee who needs an accommodation, you're not going to be required to basically hire somebody to shadow this person. But might you need to pay some overtime? Might you need a bigger computer screen, different desk chairs? Might there be some financial costs? Yes. But unless we're talking about significant costs, we're probably not there. We're generally not focusing too much, I find, on the financial piece of this. It's more about how are we staffing things? And it takes a little bit of effort to get there. It's a narrow defense. Okay, we have a duty to engage in an interactive process. So if somebody raises the need for an accommodation, we as an employer have an obligation to interact with them. It's a dynamic. You need a certain accommodation, let's see if we could grant it. We can't grant that accommodation, here's another option. Does that work? We're working often with this employee, with their medical provider to get information to support their restrictions and their needs for an accommodation. Some examples, I've mentioned some in passing, you're probably aware of many of these. It could be schedule changes, it could be some time off, it could be transferring to different positions, it could be working from home. That's been a tricky issue that I'm going to not get into too much. I think many of our workforces are back in person or in some hybrid situation that's hopefully working for us. Remote work during COVID was obviously a big thing. I know many companies are looking to move back away from that or have, but remote work still might be a possible thing that we need to consider. Different equipment, bigger screens, different desk chairs, more break times, sitting and standing variations. Those are examples of things that might be required. Leaves of absence. This is something that I want to spend a little bit more time talking about. I see a question or two coming in. I'll get to addressing it, don't worry. Leaves of absence, this is really a big overlap with the FMLA and other areas potentially as well. But the ADA very clearly would require us as employers to consider a leave of absence as a reasonable accommodation. And similar to what we would see in the FMLA, how can that leave be taken? It could be one block of time. I'm having a surgery and I need a recovery, and during that recovery period, I effectively can't work my job at all. I need 4 weeks off. Or a couple of days here, a couple of days there. Or I need the kidney dialysis treatment. I need to leave work 2 hours early, twice a week. Maybe I can make up that time, maybe I can't. But either way, you're giving me that flexibility, that different work schedule. Maybe I need a reduced work schedule. Maybe sort of like intermittent FMLA, which we're not going to get into, but it's very similar here. I need some time here and there to take an elderly parent who has a disability to a doctor's appointment, for instance. This could look very similar to other kinds of leave, the FMLA in particular, but here we're talking about the ADA. And a big difference is that the leave time, there's no bright line rule here, other than the bright line rule we already talked about, which is individualized case-by-case assessment. How long of a leave? Depends. No fixed leave period. All leaves have to therefore be considered. We'll look at some hypos where this comes up and into play. And if any of you have dealt with this situation, you know how tricky it could be. When somebody's out for a period of time, let's say under the FMLA or under PTO or under maybe a maternity or family medical leave policy that you might have in place because maybe the FMLA is not applicable to your organization. Somebody's out for a big chunk of time due to their own disability and then says to you before they come back, I need 3 more weeks off. That's tricky. Talk more about that. I want to just flag this last issue as far as background. No automatic terminations. This was a bigger thing in employee handbooks. Less so now, but I still see it. I've seen it as recently as a few months ago with looking through someone's handbook. This is basically a policy that says if you've been out for whatever set combination variety of leaves for a maximum of or a total of 20 weeks, 26 weeks, 18 weeks, 39 weeks, pick your number, you'll be terminated. In other words, you've exhausted all your FMLA, all your PTO, all your company provided leave time, any state provided leave time, you've exhausted it all, then your employment will terminate. Come back when you're able to return to work. Those policies are considered unlawful from the EEOC's perspective because they're not taking into account the reasonable accommodation interactive process, which is how much longer does this person need off? Can we accommodate that? At least in situations where somebody is taking that time off for their own condition. I have a question. What happens when an employee tells you they need accommodation themselves and not a doctor? For example, someone saying they're sick from being pregnant. Do we need a doctor's orders to accommodate? We're going to talk about sort of how that process, plays out. I will weave in comments about that. Let's look at a few hypos now. I have a main set of hypos after all the background, but I wanted to just introduce a couple. These are our warm-up hypos. I have 10. The 2 first ones are warm-ups. I think I kind of already gave this answer away effectively, and it's our warm-up. We have James informing his manager that he needs to go to treatments for a kidney condition and needs to miss work 1 day a week for the next 6 weeks. Well, I guess first of all, yes, the slides will be available, Tracy. Someone will adjust that at the end through WEDTalks. To Christina's question, this is an example of an employee telling us themselves. We are permitted, and I would certainly say you should, there's not a requirement to do it, but you should seek medical information to support the need for an accommodation. You wouldn't use the FMLA forms, those are for the FMLA. Putting together, it might be sometimes called ADA paperwork. You're basically providing to the employee for them to bring to their medical provider, a job description, another reason to have your job descriptions together and updated, and a questionnaire that effectively is saying, what restrictions does this employee have in light of their job duties? What can they not do in their job duties? What restrictions? This person needs to take restroom breaks more frequently, at least every 45 minutes in all likelihood. This person needs to stand and sit at varying intervals, can't be standing or sitting for more than an hour continuously. I have a number of clients who are in manufacturing or assembly line type work. That sometimes gets tricky. At the same time, we have folks who are available to step into someone's role on the assembly line, on the production floor, and fill in. And that's going to be something that we would need to consider. Here we have somebody coming to us directly. I think we should request the paperwork. We have a right to get paperwork from the doctor to get more information. But we don't have to have a doctor's note before we have to start considering it. We might not finalize the accommodation until we have the support, but just somebody coming to us, even if they don't say ADA, even if they don't say accommodation, even if, you know, it's not super clear, this is clearly a request for an accommodation. I need some time off to care for this kidney condition, treatment for it. The word treatment, the word condition should be flags to our managers, but there's no paperwork right now. There's no doctor's note right now. There's no mention of the ADA. The person doesn't even know what an accommodation or a reasonable accommodation is. Doesn't matter. We don't need particular words or legal jargon or buzzwords used. So clearly a request for leave here. I'm reading a couple questions that came in for a second. All right, Kristen, we're going to address that at some point in another hypo. Here's another quick hypo. Anita is struggling with complications due to diabetes, and she wants to know, she asks if she can work a part-time schedule. So we're in HR, we get this request, let's say. Her manager comes to us, aware of the request, and says they've never had a part-time employee in this department and don't feel at all that this job can be done on a part-time basis. Are we required to permit her to work part-time? Are we allowed to say, can't work part-time? This is not part-time work. We don't have part-time folks here. We've never had part-time folks in this department. I'm not even sure as the manager how I would work with that. Do we have set hours? Are there changing hours? All right, even if it's set hours, what do I do? Do I have to give up a half day of a full-time equivalent, work? Do I have to hire somebody else? I can't think about what to do. I'm the manager. How do we handle this? Any thoughts on this? I mean, feel free to put something in the chat, or if you'd like to unmute yourself if you'd like. I'm just curious. Or have you seen this before? The quick answer is we have to consider it. It doesn't mean that we're going to necessarily be required to do it, but we have to consider it. We can't just write it off as this is not a part-time position. How long is this needed? We don't yet know. If it's an ongoing way, though, we might still have to consider it. What are the demands? What are the impacts? What would this mean? Does this mean having a few people work a little bit extra? Does this mean that we allow Anita to make up this time during the work week in other ways, come in early a couple times when she needs to be off? Do we have to hire a bunch of people? Like, what is the impact? Until we even know those things, we can't even assess if we're going to have to accommodate. But as a starting point, we're going to have to consider it. The fact that it hasn't been done before, or we don't think we can do it, is not going to be sufficient. When I'm dealing with these issues with HR folks generally, and we have a manager generally who's pushing back, we need to sort of push back further on that manager. And sometimes the question becomes, from my perspective, if I told you, manager, that we have to do this, what would that look like? How would that work? And with that in mind, I think that often gets us closer to what the answer may be. We're going to have to hire 2 people in these ways. Okay, well, if I had to do this, I'd probably pull this person from here and this person from here. It'll probably mean a few extra hours of overtime each week, going forward. Whatever it might be, let's assess then what that answer looks like, and we could better assess whether we can accommodate it. A few more comments on the interactive process, and I'll answer some questions that have come in, then we'll do some more hypos. So as I've said already, in response to this first hypo, oral notice, sufficient, even if you require written notice. Plain English, no particular buzzwords are needed. A family member, a healthcare professional, somebody else on behalf of the employee could also raise a concern. Maybe the employee is in the hospital or in some kind of inpatient care facility. Side note, having in treatment care for treatment of alcoholism or addiction to prescription medications are covered disabilities. Just to sort of note, we're not going to get into drug and alcohol issues too much today. We can save that for another time, perhaps. But just a note there, we might be getting calls from somebody because the employee themselves is not available. We still have to consider those accommodation requests or that request for time off, let's say. I mentioned this in the get-go. I'm going to say it once more. Managers have to report accommodation and leave requests to HR. And if you don't have an HR department, whoever is designated in your organization, the COO, the CFO, they often get stuck with the HR roles when there's not an HR person. They need to be the point person. You need to have a point person where somebody knows they need to come raise an issue if somebody said to them they need an accommodation. And that, of course, comes to what does an accommodation request look like? And through these hypos, I'm hoping to help us remind ourselves, perhaps, but also we need to train our managers. The request for some time off for the kidney condition, that's a request. The part-time can't be ignored because it seems so outlandish to this particular manager. We need to assess it. Whether it's reasonable, are we eliminating essential functions? What are the costs? What are the burdens? What kind of flexibility is being looked for? Is transfer an option? These are some questions that we need to consider. Not clear cut, not straightforward, going to be differing answers depending on the job position and the job duties that are at issue. If a manager, important point, or if it's us in HR even, and we need to report this to somebody else, we can't, if an employee comes to a manager and makes a request for an accommodation or some time off that could be an accommodation, the manager could say, oh, go talk to HR, but that manager cannot rely on that employee going to HR. That manager has to themselves go to HR. We can't, just like an EEO complaint. If somebody complains about unlawful harassment in the workplace, you could say, well, you should talk to HR about that to the employee as a manager, but the manager themselves has to also report that. Absolutely. Same thing here. We do not want to be in the dark. It is not a defense to a failure to accommodate claim that we as the company were not aware of the need for an accommodation when that need was reported to a manager. What I'm saying here is the knowledge of our managers, just like in the EEO context, is imputed to the organization. So I complain about harassment, the organization's aware of my harassment complaint. I let my manager know I need an accommodation. Even if I don't use the word accommodation, the company's aware of it. And if the company does not engage me as the employee in the interactive process, does not offer an accommodation, if one can be offered, that's not a great place to be when the failure to accommodate claim comes. And the failure to accommodate claim, just to be clear, is a disability discrimination claim that comes typically through the EEOC or the PHRA that basically says you discriminated against somebody on the basis of their disability by failure to accommodate their request for an accommodation or engage them in the interactive process. And so that's the litigation risk that we really want to mitigate. All right, that's kind of my background before we turn to some hypos and kind of work through those for the rest of our time together. But let me peek over at our questions that are coming in. Let's see. Question about productivity we'll, I think, address in some hypos. Does the employee have to use available PTO if they need to take consistent time off for their medical condition, or can they take it off without pay? So let me address this for now. You are not required to pay people for time off that is provided to them as an accommodation. Just like the FMLA, leave under the ADA is unpaid leave. If somebody has PTO available, they could use it. The question is, can you require it? Can you require someone to use and potentially exhaust their PTO to cover otherwise unpaid time off that's provided to them as a reasonable accommodation? The answer is, here's my lawyer answer, it depends. And the area it depends primarily on is how do you treat other employees? If you're requiring that use and exhaustion of PTO for other leaves, FMLA, personal leaves, other leaves of absence that you have, then fine. You could treat the person on ADA leave the same way, but you can't treat somebody taking leave under the ADA differently, worse than other folks. So if you don't require the use of PTO for other kinds of leaves, you can't require it for the ADA, but otherwise you can. And I think that we're going to talk about the other questions here through some hypos. So that suggests to me we're all on the same page. Let's do some more hypos. Again, feel free to chime in with your thoughts in the chat box as we work through the rest of these. So here we have Brian, who has been approved for intermittent leave as a reasonable accommodation to care for a sick parent. He's now missed 3 days of work in a row without calling out. So the question becomes, and often we see this in the FMLA too, it's very similar because the leaves could look similar. He's missing work. Okay, he calls out, but all of a sudden he's gone for 3 days without calling out. Can we terminate him? Can we discipline him? Well, similar to the FMLA, while ADA absences and leave are protected absences, we can't terminate him for requesting an accommodation, for being granted an accommodation, for using an accommodation. Those are protected absences, protected leaves. But if he did not comply with the call-out procedures, then it can lead to disciplinary action. But we want to confirm before we go that route. We don't want to be too quick about it. If you're really quick to sort of jump on somebody not calling in, because they're going to be out for intermittent FMLA or intermittent ADA leave, are you doing that with everybody? I mean, how can you want to, again, be consistent and treat people who are taking these leaves similarly to others who are taking other leaves? But you want to make sure there's no emergency circumstances. You want to make sure that you're treating everybody the same way, the same kind of process. And it's possible, depending on what you know about this employee's condition, who knows what's happened? Maybe they have been hospitalized. Maybe they are in inpatient care. You don't have to wait indefinitely to find that out, but I wouldn't be super quick. I would reach out to them for sure. Reach out to them a couple of times. We need to feel more comfortable that we're trying our best to reach out to this person. But the bottom line is we could still have our expectations of the call-out procedures. Here's Kristen asked the question earlier about exhausting FMLA, but the person needs more time off. Here's some version of that. Chris, I mentioned the FMLA. I don't want to get into the FMLA too much, but some of us are familiar with it. We have somebody who has taken 12 weeks of FMLA time for back conditions, then gives us a note they need 2 more weeks off. We grant it. Then before those 2 weeks are up, we get another note, need 3 more weeks off until the next doctor's visit. The question becomes, how many times, how many extensions, for how long do we need to grant this leave? I kind of said this already, and here's just the real world example, if you will, but we can't terminate at the end of the FMLA period. FMLA has been exhausted or used, or it's not applicable. We as a company are not large enough to provide it, or you as an employee have not worked here long enough to be eligible for it. Whatever the situation is, this person needs more time. We have to consider it if it's relating to their own disability or medical condition. We do not, going back to one of the things that was mentioned in Kristen's earlier question, we do not have to accommodate an indefinite leave of absence. You can't have an automatic cutoff. You can't say 26 weeks max or 3 months max. You can't say we'll extend it 2 times, but no more. You can't have those kinds of limits, but it does not need to be indefinite. That we can't accommodate indefinite leave, or you don't have to accommodate indefinite leave. I would say you don't want to accommodate indefinite leave. You shouldn't accommodate indefinite leave. But what is indefinite leave? Depends, right? I mean, at some point, it's 12 weeks, it's 2 weeks, it's 3 weeks. 2 more weeks, I don't think we're quite there yet, but you might want to let somebody know, the employee know, that, hey, we might not be able to continue this indefinitely. At some point, though, it's going to get to the point where it's indefinite. Here's what I would say to you. This is not self-serving. I'm just being real. If you get to the point where you think this is indefinite leave, or you think it could be, or it's not yet, but you kind of see where this is going. I have a client dealing with this right now. 2 weeks, 3 weeks, 4 weeks, 8 weeks, all the different numbers keep adding up. We want to communicate to that employee, hey, you're in the accounting group. You've been out for 18 weeks so far. We've granted you 2 extensions. We're willing to grant you 1 more, but corporate tax season is coming up soon. And we need to have somebody staffed and trained if we need to fill this role before that season gets going. Kind of flagging you, we may not be able to grant anything further. That's one way of starting to kind of roll back that process, if you will, and let the person know this might not be able to go on much longer. But you really want to work with counsel. Think internal or external counsel, because it can be tricky. You want to think about your communications. You don't want to be creating a paper trail that's not going to be helpful down the road. If you're trying to cut somebody off too quickly, not going to probably be looking so good in that defense during your charge if it comes up. Somebody asked about pregnancy. Here's my pregnancy example. Bottom line here is you could look at this. Somebody says that they are pregnant, one of our employees, and need some time off. Maybe it's about coming in late due to morning sickness. Maybe later on in the pregnancy, the person has complications and needs bed rest, more significant time off. Pregnancy itself is not a disability, but complications from pregnancy, complications from childbirth could be or could become disabilities. We still need, though, to accommodate on the basis of pregnancy, even if pregnancy is not a disability. This was clear in many states and cities for some time. It's now very clear under the Pregnant Workers Fairness Act, which went into effect last year. Essentially, for our purposes right now, the PWFA says that we have to accommodate our pregnant employees in similar ways that we might think about under the ADA, needing more rest breaks, needing more bathroom breaks, needing a slightly different schedule. Maybe we have uniforms, getting a uniform that fits differently for that person who's pregnant for some period of time. So we need to think about these issues as well. Let me kind of take another quick peek through our questions here. We talked about an employee mentioning leave themselves, about being pregnant. We talked about that. We talked about not being able to return to work after FMLA. We talked about indefinite leave. We talked about the PTO issue. We'll talk about the productivity a little bit. Yeah, so to Christina's question about somebody who's injured, this person needs to wear a boot or use crutches or a cane. What if they fall on our property? This is going to again come down to what does this person do? If this person is working in an assembly manufacturing setting, I can imagine that they're going to have to move in various ways that might make it impossible to hold a cane or use crutches. But if the person is sitting down or standing up and is in a position, in other words, that is okay for their restrictions and okay for the job they have, we're going to have to consider it. People fall down all the time, unfortunately. And the person who has a cane, we might say is more likely to fall down than the person who does not have a cane. But is that true? The person who has a cane has the support of the cane. And if they know how to use it, might be better off than the person who doesn't have the cane. We can't predict who's more likely to fall, and not that this is implicit at all in Christina's question, but you could imagine a scenario where we have a few folks who are, let's say using canes, they happen to maybe be slightly older than our average age of our employee. Now we have an age-based issue, not just a disability-based issue. So it's going to come down to whether or not we can accommodate that based on their particular job and our particular work environment. Let's go to a couple of hypos. There's a few more things that we'll work through on the questions. Here's hypo 6. I want to introduce a psychological condition that's coming up a lot these days. Here we have somebody seeking an accommodation for depression. He gets information from his doctor. The doctor says, and let's not get caught up in numbers here, that's not the point. I'm estimating as Thomas's doctor, he'll probably have about 4 episodes each 6 months, each about 2 to 5 days. Let's do our math, I guess, briefly. 4 episodes, up to 5 days each. Okay, maybe 20 days off in 6 months. That's 3 days a month. Put aside if you like that or not, or you can accommodate that. But over the next 2 months, he's out 5 times for a total of 11 days. In other words, in a third of the amount of time, he's used more than half of the estimate. And he's already been out 5 times, not 1 or 2. In other words, he's well exceeding what the estimate was. Effectively, what do we do? And pattern of absences, could be violations, but we don't want to discipline him for violation of our attendance policy if he's calling out appropriately. We might, though, want to talk to him about what his needs are. We might want to ultimately go back to his doctor and get an update. This is not a recertification like the FMLA would provide, but it's similar to the extent that we might want to seek additional information. At the same time, it is just an estimate. We're only 2 months in. I don't know that I would be too quick right away to seek the additional information. But if we go another month or 2, yeah, maybe we do. Once we hit that 20 days, for instance, maybe we reach out again. But maybe this was just an intense period of time. Maybe we have a conversation with Thomas to make sure everything's going well, to find out how he's doing. It's okay to ask somebody how they're doing. We're not asking them for medical information. We don't need to get diagnoses or prognoses or look at x-rays or anything like that. But we could ask somebody how they're doing without getting into the information and the details too much. Maybe this is a rough time. I saw this happen at a client recently, some variation of this. The death of somebody, a close family member, came up as an anniversary, and that person had a lot of difficulty, needed more time off than usual. That could happen. So we want to think about the particulars again. Nick provides a doctor's note. requesting the removal of all stress-inducing responsibilities. I love this one. Is this a request for an accommodation? I hope you're laughing a little bit, but I also hope you're probably recognizing you may have seen some variation of this already. And if you're laughing because it sounds so ridiculous, some of our colleagues on this call will tell you right away, this has been seen by them. This happens for sure. The answer is this is not sufficient. It's way too broad. What is needed? What's a stress-inducing responsibility? I bet all of us on this call could pick any number of job functions that we do or responsibilities that we have that induce stress. But can we ignore this? My answer is no. What's going on here is the question. You know, we're getting our employee giving us a doctor's note. We might think it's overbroad. There's a legal term, the abbreviation, I don't want to get into particulars with legal terms, but there's a legal term abbreviated BS. We saw that in remote work sometimes. We see that in accommodation requests like this sometimes. It could be that, very well could be that, maybe likely could be that, but also there may very well be something else going on. There might be something needed here by Nick, even if the note or the information is giving is too broad or doesn't make sense or we can't work with this. I want us to follow up. I want us to ask Nick, what do you need? What's going on? We need some more information from you or your doctor. Maybe we provide that paperwork to Nick to give to his doctor so we can understand better what are his restrictions. Here are his job duties. What can he not do? Or how does he need to be accommodated to do them? So I want to follow up on this, even if we are seeing that it's too broad and not sufficient for an accommodation request. Here's somebody, Sarah in Hypo 8, who's been out for 18 weeks. Long enough, right? Gives us a doctor's note saying she can return to work, but only part-time and only with limited duties. And here the manager, maybe it's a different manager than from earlier, but here the manager basically says, until Sarah could come back working full-time and doing job duties, doesn't really work for me. In other words, all or nothing. We need her back or we really can't work with this. You probably know by now, I'm just going to do it pretty quickly, we can't require that. We can't require full-time, I said that already, and we can't require 100% fitness for duty, back full, full on. We have to consider the accommodation. If somebody could come back, not at full capacity, and we can accommodate them reasonably on non-essential job functions, we have to consider it. Can we be required to follow call-out procedures? But oh yeah, so this is Deb kind of commenting on what I said earlier, that you can require someone to follow the call-out procedures, absolutely. Oh, someone fall on sleep and different learning disabilities. I have something similar to that may answer your questions at the end. And productivity. Okay, so I think we're kind of, the last two questions that are in the chat, I think we basically have hypos. Close enough to them. Wonderful, we're all on the same page, I love it. So here we have, I know I'm going quickly, there's a lot to cover here. We really could have 2 hours, right? But 2 more hypos. Here we have Catherine, who receives a performance evaluation and in a number of areas fails to meet expectations, job performance concerns. We have performance issues ongoing and we decide we have to terminate her employment. Put aside performance management, that could be a topic we cover another time if you'd like. We get to this point. Problems, we've communicated some problems to her, continued problems, we're at the point of termination. During the termination meeting, Catherine asks for a little bit more time to improve. She blames her job performance issues on a mental health condition, and she asks us for a leave of absence to get treatment. Can we proceed with the termination? And again, if you think I've made up this hypo and it sounds academic and pedantic and just outlandish, it's never going to happen like this. Ask someone else on this call. This happens. Whether you view it as a shield or a sword approach, in that last meeting, at the last minute, someone's raising the issue. Can we proceed with termination? You know my answer starts with the word depends. It depends. But what does it depend on? This is a key area, going back to a point I've made a couple of times, where we really want to confirm that we really don't know. If it is the case that this is the first time we are hearing of this accommodation need and request, and we made a decision to terminate, we could go forward with the termination. But in this meeting, I want to pause, and I want to go back to the manager and make sure we have no record of Catherine asking for this accommodation. If we find out, and this has happened before to clients I've worked with, that our manager actually got something that they didn't realize was a request, but we look at it now and it was, now we have been on notice, maybe for some time, and we have not accommodated Catherine perhaps, and now we definitely want to pause. To answer the question and to just make the points here, we do not have to tolerate or ignore performance issues. We could have the same performance standards. We might have to think about how we are holding somebody accountable in light of the accommodations that they're receiving, but we need to treat them similarly, and that includes raising issues of performance. We can't say you've been out too much and that's the problem, but we could talk about the job performance issues that we know relate to their time off, but we want to keep them separate. And that can be tricky, and that's something we could talk more about in a different context about performance management, but we want to keep those separate and we don't have to accept poor performance. Our last one, we'll be done by 10, I promise. Last one is Zach. I'm throwing this one out just to show a complicating issue. And someone mentioned a learning disability, something similar here. We have Zach telling a manager he needs an accommodation because he has difficulty processing and understanding verbal directions. He basically wants his manager to write down in writing or email his projects, his assignments. Long and short of it is, this is based on a real situation I had with a client a couple of years ago. We need to engage in this. This is complicated. This is tricky. What do we do? This client got a page and a half, kind of pulled from the internet, I think, of suggested accommodations. The manager said, I can't possibly write down all the assignments. That's just too much time. It's unfair to coworkers. What we wound up with, just as kind of like to tell the end of the story briefly, the accommodation was the manager said Zach could go back after hearing the meeting and the assignments given out to different people. Zach could go back and type up what he understands the assignment to be. And I will look at his write-up and I will correct it. I will clarify it. I will make clear what the assignment is based on what he wrote me. In other words, I could edit that. I could look at it, but I can't take the time to write it out. That's where we landed. But it happened after some back and forths and really some creative thinking about how we can make this work. With the idea being, let's try to make it work, because we want to at least show as an employer that we've tried, that we've made the effort. My last slide is just remembering some of our takeaways, the potentially expansive coverage. I hope you've gotten clear, if you weren't already, that the ADA has lots for us to think about. It might be pretty straightforward as far as what our obligation is, but how that plays out, what the distinctions are between different people's job duties, what they have to do, if it's essential or not, what burdens it has on the organization, less about finances and more about other people covering shifts, breaks, etc. We have to remember our obligations. We could have spent another hour going through our interactive process issues, potential mistakes that we make with it, looking at 10 more hypos along those lines. We gotta leave it somewhere. I'll leave it with the manager training, with our own training and understanding about this law that has been around for a long time, but is clearly complicated and needs some thinking through and navigating. So with that, I said a lot in a short period of time relatively. I'm going to say thank you. I think Billy or Dan will say something briefly at the end. Here's my contact information. Don't be shy to reach out if you have questions. I'm happy to take them, happy to discuss them further. And I'm also happy to talk about other hot topics later in the year if you'd like to do that. It's been a pleasure coming back for another WEDTalk. I really appreciate it. I really enjoy it. And thank you again. Back to you.
Thank you for a wonderful presentation, Mark. On behalf of Bucks County and our regional workforce development partners, thanks to everyone who joined our webinar this morning. And details about the next WEDTalk will be available soon at www.buckscounty.gov/WEDTalks. Have a great day, everyone.
Bye, everyone. Take care. Thank you again.
Thanks all. Thank you, Mark. Great presentation.
You're welcome.